Good afternoon, everyone. Welcome to the Economics of Resolution, Tools for Settling High-Value Cases in ADR. So I am so excited to present this group today. When the topic of settling a high economic value case came to mind, I immediately thought of these three people: Dennis Barnes, Michael Lieb, and Judge Denise Langford Morris. So I'm very delighted that they agreed to come together to present this expert session on ADR. While they need no introduction, I will give some brief introductions. Dennis Barnes, his career spans 33 years of practicing at Barrett-Sott, Denon Dreicher PLLC, and before that at Butzel Long, two of Michigan's premier law firms. Denny's practice covered a wide range of complex commercial and business litigation and business counseling. He's a past president of the Michigan State Bar, and he now focuses practice on helping others resolve complex commercial and business disputes as a mediator, arbitrator, or court-appointed special master. Michael Lieb is a mediator with Lieb ADR LLC and devotes his time to the mediation of business disputes, including bankruptcy, and he participates in the Alternative Dispute Resolution Council, our council here of the Michigan State Bar. He also serves on the debtor-creditor committee of the business law section. Michael retired as a business trial lawyer in 2014 after many years as a shareholder at Hauser, Roth and Heller. His practice there was divided between litigation in the bankruptcy court and business litigation in state and federal courts. And Judge Denise Langford Morris, retired judge, Oakland County Circuit Court, joined JAMS in Detroit in 2022 after serving on the Oakland County, Michigan bench for 30 years. Judge Langford Morris was the first African-American and the first female dean of the Oakland County bench since its inception in 1848. During her tenure on the bench, she presided over thousands of civil, business, family, and criminal cases, including jury and bench trials. Before serving on the circuit court bench, Judge Langford Morris was a former U.S. attorney for the Eastern District of Michigan in their civil division. And she also has extensive felony criminal trial experience as a U.S. Oakland County prosecutor in all types of cases. So welcome, panel. Our topic today is the resolution of high-value cases with different ADR tools and techniques. So I will start. Denny, I'm going to start with you. We both attended at different times a training program sponsored by the AAA, the American Arbitration Association, and the EDR Institute. So I first learned of EDR, or early dispute resolution, from material that was written by you. You were describing your experience with it and how you were using it in your practice. So tell us, what is EDR and how can it be used to resolve disputes?
Well, thank you. Good morning, everyone. I'm going to share my screen so you can all see, follow along with a little PowerPoint. As you know, our topic is economics of resolution, tools for settling high-value cases in ADR. This morning, I'd like to provide an introduction and a brief overview of an outfit called the Early Dispute Resolution Institute and a process they've developed called Early Dispute Resolution, or EDR. You can't do, in the time allotted, we can't do the topic justice in every detail, but an overview. I'd like to focus a little more at the end on the formal risk analysis process and tools used in conjunction with the EDR protocols to calculate realistic damage and probable outcome ranges. And I think that can be extremely effective, not just with EDR, but with any mediation. EDR, by the way, can be used for simple cases and high-value cases, even though it's a bit counterintuitive. It's really effective in high-value cases as well, overall. So what is EDR? I mean, in a way, it sounds like old wine in new bottles, but it's more than just early mediation. The Institute has developed a set of protocols for the EDR process that bear in mind the unique challenges facing attorneys and clients trying to put them into a position to make reasonably informed settlement judgments early and efficiently. In other words, more economically and efficiently than the litigation process sometimes does. EDR is completely voluntary. The parties are in control. They can bow out anytime. But it's a process that, that has two main functions. It is, how do we get the parties sufficient information for clients to make informed decisions early? And there's a structure for doing a risk analysis. Those are the two main things. It's guided by a trained ADR neutral. The courts are involved. You might know the ABA, as Lisa alluded to, has recently adopted a resolution encouraging informed and voluntary use of the EDR. So they're rolling this out to courts and attorneys across the country. It's coming. There are some Michigan courts that have, judges that have used it. I'm not aware of any court that's formally adopted it as a concerted effort across the board. But in any event, the Institute first published these protocols in 2019. The major concepts are, again, risk analysis using probabilistic thinking. We'll get to that. And decision trees. We'll get to that. These 2-day training sessions, Lisa, I'm sure you'll agree, it was really interesting and highly. It was the best, seminar I've ever been to in the training. I highly encourage you all to go to edrinstitute.org. There they have the protocols. The protocols are also available in your materials, but they also have explanations and a deeper dive on some of the things we'll be talking about today. The process is a 4-step process. It aims at doing the same things like mediation. We all know about overcoming parties' mistrust, mitigating overconfidence and biases, and ensuring the parties have information to value your cases. Those are the third and fourth ones are particular needs of early efforts to resolve cases. And where did this come from? They did the Institute did a survey of a big group of lawyers, and they asked the same question at 3 different times in the litigation. They said, okay, the first in this, your client comes into your office and downloads, it tells you, I've been served with a complaint, or I want you to draft a complaint. Here's the problem. You do a quick review of the documents, the key emails, get a quick download from your client about what's going on. And the question put to the lawyer is, how confident are you that you can predict the outcome of the case, plus or minus 20%? Same question at the next stage of the litigation. After a closer look, you've interviewed some witnesses, closer reviewed the documents, key emails, you've had pleadings filed, you've had conversations with the opposing lawyer so you understand their position better. Same question, how confident are you that you can predict the outcome within plus or minus 20%? Third stage, full-blown document discovery and depositions are done. Summary judgment motion's been denied. We're on the eve of trial. How confident are you that your prediction's right within plus or minus 20%? Different lawyers had different confidence levels, but on average, the results showed that we have a 57% level of confidence that you made a reasonably informed settlement assessment right from the get-go. Not surprisingly, after further assessment of documents and witnesses and the other side, the confidence level goes up. But surprisingly, it doesn't go up that much. It goes up to 62%. Again, you go all the way to trial, all the pain, expense, emotion, delay, time, effort that goes into preparing for trial. You should know your case and have a real high confidence level. No, well, not surprisingly, the confidence level goes up in answering the same question. But surprisingly, maybe shockingly, it only goes up by 2% to 64%. So the question is, given the negligible increase in confidence on assessing the value of a case that comes from full discovery and motion practice, is there a better way to gather sufficient knowledge to make an informed judgment on settlement early, economically, use that that information now to settle the cases? And to do that, the EDR Institute's did a lot of study, gathered the best thinking in dispute resolution. These are concepts that we're all familiar with, and they're all embedded in the protocols. And I'm not going to spare you all of that. I'd like to highlight shortly the concepts of probabilistic thinking, risk analysis, and forecasting, because that's really some good stuff. So the process overall, very quickly, you gather the clients and the attorneys into a meeting, you explain the process, you gain some confidence, you get buy-in, you assess what are the issues, what are the claims and defenses at issue, and what information do we need to put ourselves into a position to make reasonable settlement decisions. It's a lot. There's a lot of options available. A couple quick examples, but then you move on to exchanging documents and information necessary to do that. Now, typically you say, what do you need to put yourself in a position to make a settlement? And the lawyers will say interrogatories, depositions, and document requests. You say, look, you really don't. A simple example, it's a slip and fall case. You don't need all that. What do you need? Plaintiff, you need the video and the incident report. Defendant, what do you need? You need the medical information so you can assess damages. Other than that, typically you don't need anything further. In a more complex case, you may, but let's get to it. But let's get to the nut of it and not the full-blown, everything. If necessary, one of the things you can do, for example, is I really need to assess the credibility of this witness or that witness or the plaintiff. Well, okay, you don't need a deposition. Let's go on Zoom for 15 minutes or a half hour. Ask the plaintiff, what happened? What are your damages? You can size up the credibility of the witness and the incident right there. And it's all without prejudice. So the court will get the case, put it on stay for 30 to 60 days. And believe me, that's all it takes to get these cases settled. Mostly. Sometimes unique circumstances require a little bit more time, but courts are delighted to provide it if you're making progress. But this is all without prejudice to your ability to do discovery and motion practice and all of that later. So then let's get, once we have sufficient information, there's a defined term and a key term to the process, but once we have some sufficient information to make an informed forecast of the risk-adjusted value of the case and set some reasonable ranges and settlement options for our clients, then we go to the risk analysis stage. And here it's key. They really encourage probabilistic thinking. That is not just bromides. Let's forecast likely outcomes in terms of percentages that are a little more structured, a little more scientific, and a little more focused. Is what lawyers say. We've all heard ourselves saying it or heard others saying it, is that, yeah, what do you think my chances are here, lawyer? And the lawyers say, well, it's a tough case or an uphill battle, or I like our chances. But what does that communicate to the clients? There's some really interesting studies in what clients hear. And the bottom line is it's not effective communication between lawyers and clients. So the goal is to express the likelihood of success in terms of percentages that more closely aligns counsel's and clients' understanding of the risk and allows them to focus on reasonable settlement ranges with more precision. How do we do that? This is what they call probabilistic thinking. We do it all intuitively, but it's not really intuitive. It can be more structured. And this is the goal, to get the risk-adjusted value of a case. And this is not the be-all and end-all for a settlement. It's not the same as the settlement value, but it frames our thinking in terms of how to get to a settlement value and how to bring parties along. Because often expectations are way higher or way lower, and this gives them a focused way of looking at it. You look at the weighted average of the likely recoverable damage amounts, discounted by the likelihood of their being awarded and the cost of getting there. So we've all done that. If you got $1 million case and a 50-50 shot of getting there, we all kind of know intuitively that's the risk-adjusted value of that case is $500,000. Well, if it's going to cost you $500,000 to try that case and get your recovery, well, then the risk-adjusted value is $250,000. That's simple math. But often our decisions are far more complicated than that. And the question is, is there a tool that will help us and guide us along the process? So again, the factors are percentage likelihood of prevailing, range of likely damage recovery, different, not, high, low, middle, it could be even more thorough than that, and the cost of going forward. So, as I said, it's not necessarily a reasonable settlement amount. It just frames, the question and gives us a sense of value and direction. So here's the fun thing I wanted to introduce you to. There's a website called silverdecisions.pl. It's a bunch of scientists, computer scientists and actuaries over in Poland that made this publicly available. And you can click on the website and click on where it says run here and create decision trees that help you and your clients work through this analysis. And it does all the actuarial math for you. And it's really revealing as you go through this process, because a lot of times the results are far from what you expected. I'm sure far from what clients would expect. So, let's take a hypothetical and create a tree. Let's say we get a simple breach of contract case that the plaintiff can win or lose on breach. We work with the attorneys, and you work with the attorneys and the client and say, look, what's your likelihood of prevailing? And, sometimes they'll say 95%. We've all heard that chest thumping. You say, no, let's be more realistic. Nobody, if it was 95%, we wouldn't be here. Let's say it's, 80, or talk them into something more realistic. But really, we can take their numbers and run them and get to a risk adjusted value and say, what if it was a 50% chance? And the numbers far different. But let's move on. The assumption is if plaintiff wins, it's likely a high of 500,000 of damages, a middle of 200,000, and a low of 100. So the likelihood of each is the low we've assessed at 40%, the middle at 25%, and the high at 35%. And we've inquired of counsel, what's it going to cost you to get to there? And it's going to cost $75,000 in fees. So you take that and you build a decision tree with that software that's available online at Silver Decisions. And basically you've got these circles, these yellow circles are chance nodes, the chance of losing versus winning, and a terminal node is the green diamond. That's the end of the sentence. If you lose, this is the result. So you build in negative $75,000 right there. That's the cost of going forward. And right there is our assumption was there's a 40% chance we're going to lose and a 60% chance we're going to win as plaintiff. So if we lose, that's the result. You're out of pocket $75,000. But there's also a chance you could win. And if you win, you're still out of pocket $75,000. We've plugged in this number. It's a 60% chance of winning. And if we win, there's another chance node. There's a chance we could get high, middle, or low damages. And again, right here, I should be pointing on this screen. Yeah, there's a, 35% chance we're going to win 500, 25% chance, 200, and 40% chance that'll be low. If we hit for the low damages, our net recovery is $25,000 because it's 100 minus the 75 we've invested. If, you can see the same thing. If we hit for 200, the net's going to be 125, but you've got to calculate it all the way back here to see, well, we've only got a 60% chance of winning. So what is the net risk adjusted value of this claim? We can see right there, it's $84,000. And if you played with the percentages and made it 50-50, then that number is going to change as well. And you can use that to inform and guide the clients and the lawyers, frankly, toward more information about their case. So let's take another hypothetical and look at it from plaintiff's and defendant's perspective. Plaintiff says she's got a 75% chance of winning. We'll accept that. Defendant says he's got a 65% chance of winning. We'll accept that. And both of them agree for simplicity that there's a 50-50 chance of winning. If the plaintiff wins, it's going to be 100,000 damages or 200,000. plaintiffs say that it's going to cost them $50,000 to get through trial, and defendants say it's going to cost them $75,000. So we run the decision trees for them. Again, $50,000 cost of going forward, 25% chance of prevailing for the of losing the case, in which case plaintiff would be out 50,000. But if we can see over here, there's a 0.375 chance that the plaintiff will recover 150,000 and a 0.375 chance that the plaintiff will recover 50. The net of that, it gets us to a risk adjusted value for this plaintiff from that plaintiff's perspective of $62,500. So let's take this same hypothetical. Numbers haven't changed. I'm going to move on. This is from the defendant's perspective. The defendant says he's got a 65% chance of winning. If he wins, he's still out $75,000. That's his cost. If he loses the case, he's still out $75,000. And again, a 35% chance that he's going to lose. And the average loss would be 150, because you get a 50-50 shot of losing, if you lose, of losing 200 or 100 in damages. But from the defendant's perspective, the risk adjusted value of the case is $127,500. So what does that mean? From the plaintiff's perspective, you can say, look, this is a comparison of both models. From the plaintiff's perspective, you can say, look, if you get $1 more in a settlement, $1 more than $62,500, you've beaten the probable odds that you bought into and your attorney bought into. These are your expectations in the case. These are just the probabilities. If you get something more than 62.5, you're winning. You're beating the probable odds of the outcome of this case. And then you talk to the defendant and say, if you pay $1 less than 127.5, you're beating the probable odds. So that provides us with a way to frame the expectations of the parties, and frankly cause the parties and their attorneys to become more realistic. And you can choose to share these trees with both sides or one side each, because sometimes, you've had the case where the defendant will pay 150 and the plaintiff would take 125, and those are the layup cases for us mediators to settle. Well, sometimes the decision trees are radically flipped, and you've got an ethical dilemma of how do you navigate through that. But I'm pointing at the wrong thing. There's our comparison. If the defendant does better than 127.5, he's beaten the probable odds. If the plaintiff does better than 62.5, he's beaten the probable odds. That's not the end of it. That's not, it's not a formula for a settlement value. You've framed the parties into a position where they're more realistic about their case with some tangible, clear thinking and based on their odds making. And then you apply the factors that affect every case. Of course, the subjective risk analysis factors like risk tolerance and is the defendant collectible? What's the impact on my business of going forward? And who's got what leverage? I mean, one party might be flush with money and the other might not be able to afford to go forward. So those factors. But with this tool, it's a great way to frame the discussion, make people think about it more clearly, allow clients and lawyers and mediators to communicate more directly and effectively on it. And then, once you've got the risk adjusted value, your strategy should be to settle within that range, and adjust for more options as you go forward and get to a final resolution. Are we at?
Yeah, Denny, I'm going to jump in right here because this is a perfect point for us to transition to Mike's piece, because you talked about how to do a risk analysis, how to frame these issues. And Mike, you've been a case evaluator with me for some time, and over the years, you've talked about blue ribbon panels. I look at the three of you as being a blue ribbon panel. You would be my dream team. But what does that term of art mean to you? And given this tool that Denny has used to try to kind of focus the conversation and the numbers for us, how would you walk us through what a blue ribbon panel would look like?
I'm happy to do that. Thank you, Lisa. Congratulations to you for being the
Thank
chair
you.
of our section. You've now had a few hours, and I'm sure it's all come to you with great ease. So I wanted to talk about blue ribbon panels because historically, we all know what happened in 2021 when the Supreme Court entered an order that radically changed case evaluation panels and the use of case evaluation. After several studies and a great deal of heated discussion, the court did enter an order that did away with sanctions for the most part for us for standard case evaluation. And one of the predictions by the strong dissent in that order was the elimination of case evaluation, period. My point today is that case evaluation is not dead and that we should consider strongly using what we've called blue ribbon panels. Blue ribbon panel just means that the parties have selected the panel rather than the administrative process of the courts. The purpose of case evaluation is to locate a settlement number. It is not an analysis of the likely outcome. It is arrived at by reviewing data that the parties have provided to it and providing a number that the evaluators believe should resolve the case. No surprise that the parties often disagree as to value. Certainly, the use of sanctions was a powerful incentive to promote settlement, but I'm suggesting there is a more convincing way for case evaluations to be meaningful and to result in settlements. Blue ribbon panels have been employed for many years. Standard case evaluation, just to contrast the two, is a case evaluation with panel members selected in accordance with local court rules and is an administrative process of the court. Litigants do not choose the members of the panel. The panel members are paid by the court through the court system. Similar to mediation and similar to other ADR processes, the expertise of the panel members may be a significant issue for advocates and clients. In fact, that was a factor cited in opposition to case evaluation. So the question is, can the parties create their own case evaluation process? Why, yes, they can, and they do. So I'm going to screen share the court rule that specifically addresses this. And I'm hopeful that you can see it now, because if you look at C3, this is 2.404C3, the topic is special panels, which provides that on the stipulation of the parties, the court may appoint a panel chosen by the parties. That provides control in the litigants of the process. And the qualification requirements do not apply. So when we go to the last sentence, this is a general reminder that the parties can choose other members, other ADR processes and procedures that might resolve the case. So there's your court rule support for a special panel. So a blue ribbon panel is a matter of agreement and is intended to carry significant weight with the advocates and clients precisely because the panel has been chosen by the parties. That operates, that significance and weight operates in two different ways. One, the parties have carefully decided who the panel members should be. I mean, it could be one member, it could be three members, unlikely to be two, but it could be one, could be three. And these people are chosen by the lawyers and the parties because of their expertise and the weight they carry in influencing the result. The other thing that we don't maybe think about a little as much is that once the parties have chosen the panel members, the parties have invested in that process and participate in that process. So the members of the panel are chosen, are paid by the clients. Presentation time is not limited, except by agreement of the parties. The length of argument, the consultation between the panel and the individual parties is not limited. It's set by the parties. And the nature of the award is set by the parties. The parties could agree to just simply provide a number. It could be much more extensive. You could receive a more detailed analysis by the parties. So the process is controlled by the parties, and they have the ability to determine their own destiny to some extent. So when should the blue ribbon panel be used? Really depends on the state of discovery, whether there's been mediation. It can be used anytime during the process, as long as the parties are confident that they have enough information to proceed. The panel can be used near the beginning, can be used before litigation, it can be used after mediation, it can be used before mediation. So why should a special panel be used? During mediation, the parties may simply have a disagreement, a serious disagreement about value that impedes the ability to resolve the case because they can't even find themselves in a negotiation zone that makes sense. So what are the keys here? Well, first, retaining the right panel is the key. The parties, that carries great weight with the parties. The second part is really important. And the second key is reasonable, professional, confident, experienced counsel who can work with the process and believe in the process. And the third key is the desire of the parties to resolve the case. They are invested in resolving the case. They know it needs to get resolved, and they're willing to employ a tool to do that. So what kind of cases benefit? Well, high value business cases, to be sure. I mean, we haven't defined high value, but to be sure, high value business cases, but not just business cases. Any case that has a high number potential award or jury verdict or bench trial verdict. And the case just has to have sufficient exposure to justify the expense. So how much money will be saved? Some of you may say, you can't figure that out. Why, yes, you can. If you're doing your litigation budget and value and determining what the fees might be and what the possible jury verdict or bench verdict would be, you can figure out what the savings might be. So what could the parties do to prepare for a special panel? They should think very hard about engaging the court, the judge, as a partner in the process. They may need staged discovery, sufficient discovery to get to mediation or the special case evaluation. So communicating with the court is an important process in making the court a partner. Certainly the clients and advocates need that sufficient information to believe in the process. Finally, and I can end here, finally, when the case is filed or the dispute is joined, the lawyers need to think early on about their available tools and not to say, well, case evaluation has been gutted, I'm not going to use that process. Well, no, you may want the import of a special panel and those on the special panel to help you to get to a number. But I still believe the most important key to the process, to the success and settlement, is the professionalism and creativity of the advocates. Thank you.
Thank you so much, Mike. Next is Judge Denise Langford Morris. Judge, you spent a career litigating and then deciding cases. Pulling up a screen share as I talk. Um, I can imagine having worked as a litigator and then a jurist brings you a tremendous perspective on how to resolve disputes. Now that you work with JAMS as an arbitrator and as a mediator, you probably use a different skill set to move people towards settlement. So you've talked about two tools that we're going to walk through here. Would you tell us about how you're using these tools for resolution of disputes? Hopefully everybody can see my screen too.
Thank you so much, Chair Lisa. Is everyone able to hear me?
Yes.
Okay, I want to say it's an honor and privilege to serve on this distinguished panel. All of these panelists are certainly experts in their own right, and they've been doing ADR for far longer than me. I've been at JAMS almost 2.5 years, but I did serve on the bench for 30 years, and I am very seasoned. So thank you for this opportunity to present. I'd like to start with the mediator's proposal as a tool. The mediator's proposal is something that I refer to as LDR, late or later dispute resolution, because you don't want to get involved in a mediator's proposal. And I know it's very controversial. I'm relatively new, but I do know that they work. If you do them right, if you do it at the right time, never too early in the process, usually late in the process. So therefore, LDR. But the lawyers want to know what you think. You were hired as a mediator for a reason. And why were you hired to mediate? You need to get the job done, so you want to focus on settlement. That obviously is the goal. You want to get into the rooms with the parties and the lawyers, and you're reading their clients, you're reading the lawyer's interaction with their clients, their level of control of the client, what maybe the client has been told the case is worth. And you want to pull some degree of support if they are asking you, what do you think about the case? A mediator's proposal is never what you think about the case. We just heard a presentation about a neutral analysis where you get into more of what you think about the case, but you are the mediator and you want to continue to be fair and accepted by both sides. So you want a proposal that will have some place to go, a proposal that will be accepted by both sides, else you don't want to do it. I say engage in extensive pre-clearing. I want to really listen, hear the parties, understand the lawyers, the limitations in the case, and are there any false expectations? Sometimes that abounds. You may have different skill levels of the lawyers. Sometimes a party will ask for a mediator's proposal early on, because again, they've hired you for a reason. They want to know what you think. But I err on the side of being overly cautious. It is not a science, as you heard from fellow panelist Dennis Barnes. That is truly science. I'll have to check out that site, silverdecisions.pl. But mediator's proposal is a final kind of decision where you don't want to make a mediator's proposal sua sponte. Making up a number on your own is not a good idea. And you proposing a proposal, I don't think is a good idea. I know that some mediators do that, but I believe it needs to be well thought out. So how do you make a mediator's proposal? Is it in writing? Is it orally in the moment? Maybe they need to take the mediator proposal number up the poll, particularly if you're dealing with insurance agents at different levels. quasi-governmental entities. It's going to depend a lot on the type of case. They're becoming increasingly more popular, and it can be a way to pause the negotiations if you've reached an impasse. But timing is crucial. I would always have gone through a number of hours engaged in bracketing. I'm always looking for some level of overlap. I'm expressing doubt to myself about whether or not I want to engage in a mediator's proposal if they should ask, because sometimes they will ask. And so I find myself talking to myself as I'm mediating to make that decision as to whether or not I'm going to engage in it. I would make the proposal in writing is my preference. I want to have a discussion with both counsel in advance to make sure that it's not dead on arrival. I want that hope, and I ask them to buy in. Will you give it serious consideration if you want me to give a proposal? That way they are more focused on trying to assist, and you want them to trust your value. And so when you make the proposal, you're going to include not the details of what the strengths and weaknesses of the case are, but rather that you've expended enough time, maybe 8 hours of mediation, maybe 12, maybe even longer. And so you're detailing and thanking counsel and the parties for their hard work up to that point. You want to focus on your background. Maybe there's something in your background that will assist the parties as they go with the proposal in an effort to persuade their clients to accept your number, because there's a lot of that going on, particularly if it's being taken up the poll. So I buy permission to give the proposal from both sides. I get them to agree that they will give my proposal serious consideration. And there's a lot of psychology involved in that detail. We don't have enough time to get into that, but you're working to get each side to do the hard work to come back with a yes. I'm going to give them a limited amount of time to make that decision. It depends on what's going on. I recently did one. The holiday was involved, back to school, those kinds of things. And I wanted them to have sufficient time to really dwell on the proposal. There are a lot of other things that I could go on, but I think we're going to be out of time. I will say this: I am available if there's anything that I can do to help any of you out there that are thinking about a proposal. I like them, and I have ideas about proposals that we just don't have enough time to share. Family law proposals and many business disputes, you want to deal with the additional issues first before you get to a number. And it's just like any mediation. You want to make sure that you're not going to have anything that's just going to throw the number out the window. You want to deal with the non-monetary aspects and get someone to buy in on that. So you're thanking the parties, you're noting that the agreement is not based on the value, what you deem the value of the case to be. It's not a personal evaluation of the merits, but rather an assessment viewed on settlement based on your hours pre and post mediation discussions. So I would say they definitely would not know if the other accepted. It's double blind, and I won't say a thing. Now, I don't end if they would not accept a mediation proposal. I would continue to work with the parties. In fact, I will assist them with the fine tuning of the other aspects of settlement. And I just wanted to briefly mention ESI. ESI, I've worked as a discovery facilitator on high-profile multi-million-dollar matters. I have one in particular I'm thinking of now. It's a lot. There's a lot involved in ESI. And I will say this: when you're dealing with hits and custodians and the type of behavior that comes out with discovery disputes, it is really important that you keep your ears high and open, because there may be opportunities to resolve the case, resolve the dispute. And a lot of this depends on whether we're talking about pre-lawsuit, in the midst of a lawsuit, or post, where there's an appeal or something and they've come to you to try to help resolve the matter. So I am a lawyer. I could go on and on, as you know, but I'm going to be quiet at this point. Thank you. Thank you so
Well,
much, Lisa.
Judge, we do have a little extra time, so I wanted to ask if you want to, could you get into just a couple of, you've got best practices for ESI protocols, and you were talking about the fact that you're able sometimes as a discovery facilitator to resolve even at that preliminary stage. What does
Yes.
that look like? When have you been able to do that?
Absolutely. Well, I think the key issue with serving as a discovery facilitator, if you will, particularly where you're talking about thousands of documents, sometimes 10 custodians, the parties can't agree on the terms, the hit terms, or things of that nature. It's imperative that you prepare early on, because usually the judge has not done it. So you want to prepare an order appointing you as the discovery facilitator that gives you the latitude to work with the parties, to call them in at certain times, to convene monthly status conferences, that gives you the opportunity to rule, if you will, or decide the disputes on every single aspect of the dispute. Now, you're not taking away authority from the court, and you include in the appointment order, which the judge will happily sign, because they want someone to help them with these discovery disputes. So you're going to include that the court retains full authority over the case, including the right to accept, reject, or modify any of the language of the facilitator, any recommendations, none of which are binding without an order from the court. So the parties have that as an option, but yet you've been given some authority, and they know the judge is relying on you and looking to you to help them resolve their discovery dispute. So that order is crucial, and the language in the order is imperative that you have broad enough opportunity to work with the parties on a regular basis, usually regular status meetings, if you will, or if something comes up and they need to present an actual motion to you.
Okay, I knew you all would have a lot of great information. We've got a couple extra minutes, and there's a question in the chat. I believe it may be in context for the blue ribbon panels, but the question is, can the parties stipulate to settlement sanctions? Mike, you and I talked, I'm going to start off with Mike, if you want to grab this one. We talked about that, the elimination of sanctions under case evaluation, and would that be applicable to a panel? Do you want to start off with that one?
Yeah, I think the parties could stipulate to that. They designed the process, but I think that my personal view is that I think that it's not likely to happen by contract in a high value case. I think the key to resolving, to a successful blue ribbon panel isn't the sanctions, it's the nature of the panel and the commitment of the lawyers to the process. So yeah, you could probably do it, but I can't imagine if I were on the other side, why would I do it? What's the bang to do it? That's not why you're doing a blue ribbon panel. You do it because you want somebody whose credibility you trust helping you resolve a case.
Any other questions? You can raise your hand or put it in the chat. So Denny and Judge Langford Morris, I'll ask you all, outside of the term sanctions, do you all see people building in some sort of teeth or some sort of timeline or some sort of responsibility, Denny or Judge Langford Morris, into the process, some sort of way to hold the other side accountable? Do you see that at all?
Well, it seems to me if you want case evaluation, you can always stipulate to that, including the sanctions, to provide an incentive to, for each side to accept. And again, it comes back to what Mike said about trusting your either case evaluator or panel. But I don't see it, I've never seen it in a mediation or an ADR complex, because you're trying to get the parties to a voluntary resolution through agreement, not through a case evaluation number.
Got it. Okay. Any last words from the panel then? Oh, there's a new message. Hold on. Let me see. Shell Stark said, great presentation. Thanks for your time. Shell is someone that comes to mind for a blue ribbon panel as well. So
Amen.
that's
One final thought. It's not that easy. That Silver Decisions website, it's got a manual and everything. It shows you how to use it. It's still not that easy. It's relatively easy to do. You need some guidance through it. So if anybody had any questions or wants a little tutorial on how to use that site, feel free to call me. I'd be happy to do it. You know.
yeah, everyone here on the panel has thrown that out as an option, and I appreciate it. Thank you all so much for your time and expertise. Take care.
Thank you.
And,
Thank you.
and please
Thank you all.
select your next session. We'll see you at the next one. Take care.